Sorry, gentlemen, good morning. Hello.
Morning.
Sorry, Mr. Paul, Mr. Emmanuel, good morning.
Morning, sir.
Yes, so how are you?
Fine, sir.
Yes. Mr. Paul is the claimant.
Good morning, my lord.
Good morning. Is that Mr. Paul or Mr. Paul? You are muted.
This is Stephanie, but Paul is also available, sir.
Okay. Sorry. Okay, good morning. How are you? Is the claimant in court? Stephanie. Claimant absent, ma?
Yes, my lord.
Okay.
I don't know if he has joined.
Who has joined?
My lord, I don't see the claimant here.
Okay, so claimant absent.
Yes, my lord.
Okay, thank you. Okay, parties absent, sorry. Yes, Stephanie.
Mr. Paul is online.
Okay, it's online, okay. Paul.
Omojiade, chief Paul.
Omojiade with
Stephanie.
With Stephanie.
Onga.
Stephanie Okonga. Oje Kere for the claimant. Yes, Mr. Emmanuel.
Lord.
Is that Mr. Emmanuel?
Yes, my lord.
E.G.
Jeffrey.
Yes, Jeffrey. Yes, Mr. Emmanuel, we are gathered to further address the court.
Okay, so thank you, my lord. My lord, based on the request at the last adjourned date, we
Yes.
have filed our further address
Okay.
to clarify our response regarding the propriety
Okay.
or otherwise of the dismissal of the claimant for his being away from work for about 223 days without permission.
Yes, your further address was filed.
Was
filed on the 28th of October. Okay, October. Yes.
Okay.
Yes.
I should just proceed to adopt it.
Yes.
We have a further address dated the 28th day of October 2025. We count just one issue for, no, we didn't even count an issue for the termination. We seek to adopt it as our argument.
Yes.
we seek to adopt further address dated 28th of October 2025 as an argument in this suit.
Yes.
So, my lord, may I proceed to adumbrate?
Okay, you can do so if you want.
Okay, thanks from my lord. My lord, the claimant raised a couple of issues or has argued a couple of things. And to summarize it, the argument of the claimant is this, that the penalty or the punishment of the claimant is too harsh, that the appropriate punishment for being away without permission on sick, being away while being sick without permission is withholding of salary. While for malingering and for disclosing of official information, the proper punishment is termination. But my lord, we disagree.
But did you not even Mr. Emmanuel?
Yes, my lord.
Emmanuel.
Yes, my lord.
Mr. Emmanuel.
Yes, my lord, I can hear you, my lord.
Mr. Emmanuel and all that things, didn't he? You only made a recommendation. Trying to say that you didn't terminate him on malingering and disclosing of information to a third party. You only terminated him on for being absent without leave, isn't it?
So, well, my lord, it is. He had about two things during his disciplinary proceeding.
No. But yes, but that one is just a recommendation. Was there any termination letter, any letter given to him for malingering?
No, not for malingering, but for disclosure of official information.
Yes.
He admitted it during the
proceedings.
The proceedings. So
yes,
that one is settled. It's not a fact an issue. It's settled.
Yes. But he wasn't given any letter, isn't it?
My lord, yeah, it will be awkward for somebody that will be dismissed to be terminated as well.
Okay.
So that is the
but you can say since he was charged, he was charged with many counts. You can indicate in the letter that he is dismissed on the basis of so offense and terminated on the basis of so offense. But maybe they'll run concurrently as we are doing in court, isn't it?
Yeah, maybe in court it would be. If we had done it that way, it would still be a bit awkward.
But
it will be a bit awkward because
in any case, he was terminated for being absent from work. Isn't he? He was dismissed.
Yes, he was dismissed
for being absent from work.
Absent from work. Why found liable? Why found liable for disclosing of official information, which is what he's not contesting. He has admitted that one.
Yes, but it didn't issue him any termination letter.
Yes, my lord, that's what I'm trying to explain. That if we issue a termination letter.
No. What I'm trying to say is that, can I make any finding on that? Can the court go into that and determine the proprietary or otherwise of the of his recommendation for termination on the basis of the of malingering.
Okay, I see what my lord,
Yes.
that because he was not issued a letter of termination.
Yes, because
It
there was
might be,
only a recommendation. There was only a recommendation.
yes.
So let us concentrate on the issue of on the issue of what do you call it?
Sick leave.
Yes,
Appropriate.
sick leave.
Okay,
Sick leave.
the propriety of his dismissal.
Yes.
Okay, thank you, my lord. So,
Yes.
my lord, the point we are making is this, that the fact that he is sick or
Yes.
does not.
Was not in dispute, isn't it? Was
No,
not in dispute.
it wasn't in dispute. It
Uh-huh.
wasn't in dispute. Then,
Uh-huh.
my lord.
So, Mr. Emmanuel, since the issue of his being sick is not in dispute, Mr. Emmanuel,
Yes, my lord.
he has been seen by some of your doctors, isn't it? Some even
Yes.
said that he wasn't fit to report to work.
Yes, my
Isn't
lord.
it?
Yes, my
So
lord.
what I'm trying to say is that since the issue of the sickness of the claimant wasn't in dispute, why wouldn't you have applied the provisions of that section, the one that is saying that somebody's salary would be withheld? That is section. Why the section? That's 664 something.
Yes, my lord. Yes, my lord.
Instead of going for dismissal, why wouldn't you go for withholding of his salary? Since the issue of his sickness, you have investigated. This
Yes,
man
my
had
lord.
this accident. This man went to a male hospital. This man went to your doctors. They saw him. Some have even, recommended for something, even though he opted for traditional setting, you understand, treatment. So what I'm trying to say is that the issue of his sickness is not in dispute. So since it's not in dispute, you have investigated. Then why wouldn't you have applied, since he didn't follow the requirements under those provisions for bringing for applying for attaching his application with medical certificates from your hospitals? So why wouldn't you have applied those provisions that he will only forfeit his salary instead of dismissing him?
Okay, so
Because in one of your submissions, you said any holding you said it's against this factual background that we contend that dismissal was an appropriate disciplinary act for his being absent from work for 2 to 3 days. He cannot insist on having things his way and expecting the bank to indulge him. He might have as well insisted that his arm gets better naturally before resuming work. We submit that he was not on sick leave for the period of 2 to 3 days when he was away from work. Any holding to the contrary would set a very bad precedent for a public organization like the bank. It will mean that as long as an employee has communicated that he's sick, he can go away for maybe 10 years and his position will be waiting for him. Mr. Emmanuel,
yes, my lord.
the position of this case is different from your scenario here. In this case, because when somebody just goes on his way and tells the bank that I'm sick, the bank is going to investigate. When it is investigated and found that he wasn't actually sick, he'll be dismissed, isn't it? But in this case, he was actually sick. There was an accident. He reported it. He had been going to a doctor's. But his only fault is that he didn't follow the procedure under, section, what do you call it? I think it's
The provision for sick leave.
Yes, provision for sick leave. I think that's only his fault. But the fact that he had an accident, the fact that he was sick, is not in dispute, isn't it? So because this is different from where a person would just go his way, for 10 years and then come back and tell the bank that I was sick. That would not be acceptable, Mr. Emmanuel. But in this case, when he had that accident, it was reported, isn't it?
Yes.
The bank was no. The doctors of the bank were in the know. So that's just my so his only fault is that he didn't follow the requirements under the provisions for sick leave, isn't it?
Well, my lord, it is broad. It's not just that. Let me explain.
Okay.
So, this scenario is a very unique one. It's not just that he didn't follow the procedure.
Okay.
One,
yes.
According to him, if he had done the surgery at Imel Hospital, he would have been.
Yes.
It would have taken 6 weeks to recover. But he opted for a different one. That is why we said, so if he had said, okay, because I am sick, I don't want any treatment, I am going to sit at home, let me heal naturally. Should the bank...
Yes, but even at that, he can forfeit his salary now. He can forfeit his salary. Even at that, he can forfeit his salary.
So, my lord, okay, let me talk about his salary now.
Okay, yes.
So if he does that he doesn't want to receive proper treatment, and it takes maybe, and the bank knows he's sick, and it takes maybe 4 to 5 years for him to heal properly, because he's sick, should his position then be waiting for him? Should the bank
you can stop his salary? You can stop his salary.
But the problem is not just stopping his salary. The problem is also his role. If somebody that is sick and refuses to take proper care of himself, and then decides that because I will do it at my own pace and at my own time, and then spends like 4 to 5 years outside of work, it's not fair on the bank to just withhold his salary, because his role, they need him back. They need him back to work.
Okay, then is it fair to also dismiss him?
Now, let me come to his dismissal. Now, the procedure for sick leave is not just that he did not send medical certificate. He could not have sent the medical certificate because he is at home. He wasn't an inpatient at any hospital. So, assuming this provision for withholding of salary would work where a person is an inpatient at a hospital, but did not follow the procedure of sending the certificate. So you can say, okay, this person cannot come to work.
Okay, let me record this. So they said the we further submit that the procedure procedure for Emmanuel.
Yes,
Can
my
you hear
lord.
me?
Yes, my lord.
You are saying that the procedure for future of salary is what?
Yeah, so I was saying that the procedure,
Yes.
he didn't even meet
You
the.
are saying that the procedure for future of salary is only applicable with regards to an inpatient, isn't it?
Yes,
Not
an
not
patient who failed to
yes,
comply.
not outpatient, isn't it?
Yeah, yes. So the procedure is, if it is for an inpatient who failed to submit the certificate.
Yes,
An
respect of
outpatient, okay,
an inpatient who failed to
to
submit
submit the necessary certificate.
the necessary medical certificates. Yes,
It would
but
not.
but but but,
It
but him being an outpatient, he the requirements in the in the provisions for sick leave will not apply.
if he's an outpatient, the
Yes,
intention the intention of this provision is so
yes,
that people don't just take leave anyhow. If you're an outpatient, you
yes,
might as
yes,
well come to work.
yes, yes, yes,
If
yes,
you're an outpatient, you might as well have resumed work.
yes, yes.
It shows that your illness is not serious enough.
Serious. Yes,
It's not.
yes.
It shows that your illness is not serious enough
Enough. Yes,
for you
yes,
to be away from work.
yes. I understand. Understand.
Now, and that is our first level of argument.
Yes,
Our
I've
second
seen that.
argument is that
Yes,
the provision the provision that says withholding of salary is
yes.
not an exclusive one. It doesn't say that that is the only punishment that
Okay,
should be melted out to somebody that is away from
okay,
work.
okay. So the penalty for
Withholding salary
withholding salary
is
is
not,
not exclusive.
yes, it's not the only punishment for
Okay,
being away from work. The position that says a person that is away from work for 30 days does not exclude people that are sick.
so it can be meted out in addition to other punishments.
Yes, exactly.
Okay,
That's my point.
okay, yes, yes,
So now, then finally, let me just talk about he's going to meet the doctor for certificate of fitness.
yes,
So I, I think he was just being tricky with it, and here's why. He was supposed to. He was away for a long time. He has not
yes,
recovered properly,
yes, yes, yes,
and
yes,
he's coming to collect certificate of fitness.
yes,
Meanwhile, if he had, then there was no point of him stopping the work in the first place or being away in the first place. If he could have resumed.
yes,
So if he's an inpatient, it's a different thing. We know that he's hospitalized and he has been in the hospital for a long time. But this one,
Yes.
he's at home. There's nothing to show that he has. In fact, the doctor said he has not recovered. So what is the point of him being away for over 223 days without recovery? The certificate of fitness is issued to people that have recovered.
Yes. And he didn't recover.
And it goes with people that are impatient. Not just somebody.
Okay, but Mr. Emmanuel, let me ask you. Under the provision for sick leave, that is 5.3. It starts from 5.3.1, where it is stated that before those provisions would apply, the claimant has to be an inpatient.
Yes.
But I'm now with the human resources policies and procedures. I'm trying to go through those provisions, whether I will see anywhere that is stated that before the provision for sick leave would apply, somebody has to be an inpatient.
Madam, okay.
Okay.
29.
39.
29, page 29.
Yes. You see where it's in the case where it stopped?
It says sick leave certificate from the fourth paragraph or so.
Fourth paragraph. Page 39. 29, yes, 29, yes. 29. Yes.
It said sick leave certificates from health centers, teaching.
Yes, training and general hospitals and other medical institutions will be accepted only when.
Yes. The staff member is actually receiving treatment from such hospital as inpatient on admission.
Mm-hmm.
And when he or she has been referred to such hospital or centers by the bank's doctors or the standby hospitals.
Okay.
So we then proceeded to say such certificate must be produced within 24 hours of the admission of the staff into the health establishment.
Okay.
So it then proceeds to the next paragraph. It says salary may not be paid for absence from duty on the ground of ill health not covered by the procedure laid down above, which is for inpatients.
Okay.
So the procedure laid down above is.
And the claimant in the instance case, was he an inpatient or outpatient?
He was an outpatient. He was not an inpatient.
And there was no proof that he was an inpatient.
There's no proof that he was an inpatient. He only got medical. In fact, there is proof that he's an outpatient because one, he had been going about and he said he preferred traditional bone treatment.
Yeah.
There was no place that he said, even in that traditional bone setting treatment, that he was admitted there. No, he wasn't admitted.
Yeah, no, I mean, you mean there's no proof that to state that he was admitted?
Yes, there's no proof to say that he was admitted there.
Okay. But what about the report from your doctor saying that he was not fit to report to work?
So is under the paragraph 20, return to work after sick leave. An employee who has been on sick leave should not be allowed to resume duty until he or she is certified fit by a bank doctor.
Yes.
Now, in this case, he was not even on sick leave.
He was?
He was not even on sick leave because nobody
Okay.
granted him the sick leave. That is one.
But why then did your doctors, say that he wasn't fit to report to work?
Because he had not even recovered.
He didn't recover, isn't it? He had not recovered. That's why they said that he was unfit to report to work. So it means the issue of his sickness wasn't in dispute.
No, my God, we are not disputing it at all. We are not disputing it at all.
Okay.
We are just saying that the length of the time he spent away from work was entirely determined by him. The document he produced from EML hospital,
yes,
EML hospital, email hospital, is to the effect that he will be away for 6 weeks.
Yes.
But he chose traditional bone setting instead. And even at that traditional bone setting, he had not recovered sufficiently. He had not recovered. So what is the point of being away from work?
Why didn't you only charge him for malingering instead of the for being absent without
leave?
Leave and subsequently dismissed him. Instead of that, why didn't you just charge him for that malingering?
So the reason we didn't charge him for malingering is that one fact could lead to different things. I think
yes.
It was the bank's prerogative.
at the expense of an employee, Mr. Emmanuel, at the expense of an employee.
Well, not at the expense of an employee.
Yes, because Mr. Emmanuel, there's no dispute that this person was sick, and there's no dispute that he had not recovered, isn't it?
Yes, my lord.
Yes, his fault was that he chose to go for medical traditional treatment, and number one, he didn't comply with the provisions under the sick leave procedure. So why didn't you take the lesser offense instead of the more serious one? That's just my observation.
Because maybe because malingering would have been difficult because he was actually injured. Malingering would mean
yes, he was actually injured.
Malingering would mean that he was pretending to be injured and he was just dodging work or was just being away from work.
I thought he's choosing for the traditional treatment can may amount to malingering.
Well, no, my lord, yes, I admit that.
Yes, he's choosing for traditional treatment. I think it can amount to malingering, isn't it?
Yes, my lord.
Okay. In any case, are you done? So I go back
Yes,
to Mr.
substantially, yes, madam.
Oh, is there anything that you want to?
Yeah,
Yes, you want to add?
um, but we just want to say that the
Yes.
the one fact can give rise to a number of misconduct.
You have stated that in your written address.
Yes, madam. We submit that the suit be dismissed.
Okay. Okay. Thank you, Mr. Paul, Mr. Emmanuel. Thank you.
Thank you.
Yes, Mr. Paul. Mr. Paul, you are muted.
My lord,
Yes.
the claimant further written address dated 29th October 2025 was filed the same day, my lord.
Yes.
And we adopt same as our final further argument in this matter.
Yes.
By way of further elaboration, my lord,
Yes.
without conceding
Yes.
that the claimant disclosed official instruction, the punishment under the handbook for that offense is termination and not dismissal. And secondly, without conceding that there was the issue of malignant,
Yes.
the punishment for that, my lord, is termination.
Yes.
And dismissal, my lord,
Yes.
indicate that the punishment meted that were excessive. And such excessive punishment are liable to be set aside by this honorable court.
How?
Because where there is a specific punishment for an offense, parties
Yes.
are bound by the terms of their contract. You
What
cannot go outside the terms of the contract.
what is the specific punishment?
Is termination, my lord, if it's proven.
In respect of the
Malignant.
no, in respect of the absence from work without leave.
No, absent from work without medical cover is forfeiture of salary for the period, my lord.
Okay, then what do you say about the provision talking about absence from work without leave, without approval?
That is the absence from the aspect that borders on malignant. That is malignant, my lord.
No, it's not malignant. This thing is the punishment is dismissal. The provision under which the claimant was dismissed, I think, is absence from work without leave.
My lord, going by the medical reports, and their medical reports and excuse duty avail the defendant by the claimant.
But Mr. Paul,
Yes, my lord.
What will you have to say about the submission of Mr. Emmanuel that the provisions under section 5.3 on sick leave?
Apply to inpatient.
Yes, inpatient, yes.
I disagree with that, my lord.
So,
because, my lord, we should not read into a document what is not present there. My
it's
lord,
like, yes, I can hear you.
I want to go further, my lord. In the world of work, of which I worked for 31 years, the fact you don't need to be an inpatient before you can be given.
No. Let's concentrate on the human resources policies and procedures of the defendant.
Yes, my lord. That's where I'm going, my lord.
Yes.
The human resources policy and procedure manual did not specifically mention that before you can be availed medical excuse duty, you must be an inpatient. If you are an inpatient, you will be entitled to the sick leave.
Yes.
And the practice mainly is that when you are being discharged, if you are not fit for work, the hospital can give you excuse duty that you will not be fit to return to work for so and so period. In the instant case, my lord, the claimant opted for the traditional bone healer, not by choice, because initially there was a letter by ML Hospital to the defendant that the claimant will need surgery and they require approval. That approval never came. And it was almost about 3 months when the claimant went to the hospital and was told there is an approval for you to undergo surgery.
But Mr. Paul,
that he decided for the traditional bone setter.
Mr. Paul, can you hear me?
Yes, my lord.
What I want to know is the provisions under the sick leave procedure, where one would be said to have forfeited his salary.
Yes, my lord.
It's only talking about an inpatient, isn't it? An inpatient. In this case, is it proving that the claimant was an inpatient?
The evidence before the court, my lord, there was a report from the traditional bone healer where he was taking a treatment. And I also mentioned that that provision.
That was a report.
Yes.
Okay. So let me record this.
My lord.
Yes. You said there was a
My
report
lord,
from.
there was a report from the traditional bone setters.
Yes, that the claimant was an inpatient.
He was admitted in the traditional bone setters clinic. Is there in evidence, my lord? And secondly,
That the claimant was admitted.
it's a
Mr.
comprehensive report that the claimant was there for treatment and all other things connected to it. It's in evidence, my lord. But apart from that,
Okay, that the claimant was there for treatment.
yes, there is a report.
It didn't indicate. It said exhibit what?
Well, my lord, I don't have it here because it's there in evidence. It was tendered.
Okay, but what did it indicate that he was an inpatient?
I think it was, there's indication that he was an inpatient and at a time an outpatient also. It's
Okay.
a comprehensive report.
But it didn't show that he was an inpatient all through the two to 3 days.
No, my lord.
That he had been away from work.
Yes. Then furthermore, my lord.
Yes.
The claimant, the query that was given, I think, indicated the issue of malignity.
Yes.
And the issue of being absent without official permission,
yes,
was not brought to the fore. Even in the course of trial, man. The issue was malignant and not being in the office without medical certificate. Those were the issues. So to that extent, my lord, the issue of being away without if you want to charge for any offense, you disclose it, and evidence will be led to establish or disprove what you have said.
yes.
It should not be an ambush, my lord, because dismissal carry with it a stigma, and it has to be exercised sparingly. It should not be a sword to be used by the defendant. It should be a shield, my lord, not a sword.
I'm even looking for the dismissal letter. It's exhibit what?
Let me see the.
Oh, just lumped. Okay.
Is exhibit SU20, my lord.
Okay, the dismissal letter.
Yes.
Okay, SU20. Okay.
Yeah.
SU20, because I want to see. Okay. Okay, and the dismissal was for okay, just for it's stated that it's for gross misconduct.
Yes.
That is the absence from work without leave, or what?
Well, that is the law is right that where you state that an employee has committed gross misconduct, the nature of the gross misconduct must be disclosed. It should not be by speculation or not.
No, but disclose in the query and in the disciplinary proceedings, isn't it? Not in the dismissal letter, isn't it? Is it not?
No, in the dismissal letter, my lord.
It has to be disclosed in the dismissal letter.
The reason for dismissal.
When they say misconduct, they say misconduct, isn't it? Okay, in any case, you can go on, Mr.
Yes, my lord. Our position is that without conceding that because the summary of it all, we are all in agreement that the claimant had an accident.
Yes.
He went to the bank. The defendants authorized the bank hospital, where the bank's doctor referred him to another medical facility, my lord.
Yes.
Those are not in disputes. There is evidence also that the request for surgery by the bank's hospital was never attended to within a period of 3 months. That was why the claimant opted for the traditional bone healer.
But when he went for the traditional bone healer, he wasn't an inpatient there, isn't he? He was not an inpatient.
The report indicate that at a stage he was admitted there, and thereafter he was now coming as an outpatient. Is there in the medical in that report?
But Mr. Paul, will you agree with me that the procedure under the provisions of section 5.34 with regards to sick leave is not applicable in the case of the claimant being not an inpatient?
Not, with all due respect, my lord.
That is on the issue of salary. On the issue of forfeiture of salary.
The issue of forfeiture of salary applies to both, whether you're an outpatient or inpatient.
But the provisions only says but no, we're talking about the conditions of service of the defendant. The condition of service say it's only an inpatient who has failed to produce medical certificates. You understand? Will forfeit his salary. That means in the case of an outpatient, the issue of forfeiture of salary does not even arise. What will apply is the penalty for refusing to be present in work without approval. Isn't it?
Yeah, my lord.
Yes.
My lord, the 233 days or thereabout mentioned by the defendant.
Yes.
There were medical reports, medical certificates.
Yes, indicating that he was an inpatient.
Yes, those reports and certificates were issued by even the Central Bank Hospital, my lord. Some of them.
That he was an inpatient, or he was just sick. Yes.
My lord, there is a provision that when the claimant went to the hospital, that is where he was admitted first.
Yes.
He was given medical, he was given sick leave.
Yes.
And the requirement, we also indicated that in the final address, that where the employee is not an inpatient,
yes,
the bank has a duty to forward a form for extension of that sick leave to the house of or the address of the claimant or the staff.
Okay.
That was never done. If you read.
Yes. Yes, because you have to round up, Mr. Police. If I read
I'm rounding up. My lord, that form was supposed to have been sent by the defendant. And the mischief behind that is for the defendant to confirm whether the staff is actually sick or not. And eventually that position was confirmed by the bank's authorized medical doctor, who told the panel that there was even a medical report written that the claimant was not fit for work.
Okay, then under what circumstance can somebody be dismissed for being absent without without leave?
Yes, my lord. If, for example, there is nothing evidence to show that this person was sick, whether as an inpatient, outpatient, or what have you, there is nothing on record to show the state of that staff at that time. But if there is any element that that staff was sick and even reported back to the office, and also in evidence, my lord, there was a time the claimant reported for duty and his boss instructed that they should not mark him present in the office. It's there in address. So the circumstances under which his lordship, the issue raised by his lordship will apply if there's nothing on record to know whether the claimant was sick or there's nothing at all to ascertain his whereabouts that will be prolonged absence without any information about the state of the staff, which does not apply in this case because they already know that the claimant was sick, and when he presented himself for duty to the hospital, there was a certificate that he was not fit to work.
Okay.
If that certificate was not applicable to the claimant, the bank's doctor wouldn't have issued the certificate, my lord. On that score, my lord, I urge His Lordship to grant the claimant's reliefs in this suit and discountenance the argument of the defendant as they are largely speculative and cannot support our defense, my lord.
Okay.
Almost grateful.
Yeah. Thank you.
My lord, I don't know if I could reply in less than 3 minutes.
To say what? What do you want to say?
Just to reply in less than 3 minutes.
Yes, say it. What do you want to say?
Okay. First, the bank did not issue any medical certificate. What the hospital that issued it was Email Hospital. 2,
recommending for surgery. Recommended for surgery, isn't it?
Yes, so yes, the Email Hospital gave him some certificates for 2 weeks. Those 2 medical certificates were not part of the 223 days. It was excluded from the 223 days.
Okay. Okay.
Now, the heading on page 28 of the Human Resource Manual.
Yes.
It says medical certificates. I'll just quickly read it. Except where a member of staff is away for a single day, absences claimed as sick leave must be covered by a medical certificate. The number of single uncertificated sick days taken by any staff may not exceed 3 in any 1 year. That means a staff should not be absent for more than 3 days without certificate. Now, a staff is only entitled to this certificate if he's an inpatient. So our point, and the point we've been trying to drum since, is that even the certificate, because the claimant is not an inpatient, he couldn't have been entitled to this certificate in the first place. It's not just a procedural error. Maybe he failed to do something. In the first place, he couldn't have been entitled to the certificate because he's not an inpatient. I've gone through the report of the traditional. There is no identity. Let me not say there is no place. I think it's safer to say I did not see where he was described as an inpatient, and I also did not see the number of days that he was referred to as an inpatient, that he was admitted as an inpatient at the traditional bone setting clinic. I did not see it, and I did not see the number of days. So finally, I don't think the claimant can say, the claimant is in doubt as to what the gross misconduct against him is. There was a full panel hearing. It was also during the panel hearing. So, my lord, you're muted. I can't hear you.
I said it's even stated in the manual that the absence from duty without permission is one of the yes, and
yeah. So
things that will amount to misconduct. Yes.
So yeah. I just want to say that the claimant is fully aware while he was dismissed. He's not
I appreciate that. I understand that.
Right. That's all from my end, my lord.
Thank you. So, given the circumstance, case is adjourned to 12th of December 2025. That's next Friday for judgment via Zoom. The link will be communicated to the parties.
And the company.
The court please.
I'm most grateful, man.
Most grateful, my lord.
Thank you. So, gentlemen, Mr. Paul and Emmanuel, thank you so much. I appreciate your arguments, your patience, and thank you for the company. So till in absence of any other thing, I say good afternoon and I leave.
Most grateful.
Thank you. Thank you.